Sir, this vehicle's being towed. You can't park here.
Officer, that's my spot.
Yeah, you wish. Back up.
Okay. What makes you think this car is illegally parked?
Because you don't look like you work here.
Chief Judge Marcus Ellison, and you just lost your job.
Judge Marcus Ellison was sitting in his chambers on the third floor of the County District Court reviewing documents for the afternoon hearing when his judicial assistant entered with a disturbed expression. It was a Tuesday in April at 11 in the morning, and Marcus had just finished the morning session of criminal cases. He was 52 years old, had been on the state bench for 12 years after a distinguished career as a criminal defense attorney, and was known for his patience in court and even temperament even in the most contentious cases. But the news his assistant, Sarah Chen, was about to deliver would test that patience in a way he had never experienced before. Sarah said there was a problem with Marcus's car. He had parked in his designated space directly in front of the courthouse that morning, as he did every business day, the space clearly marked with a permanent metal sign saying, "Reserved Judge Ellison." It was the same space where he had parked for 12 years. Every court employee, every regular attorney, every police officer who worked in the area knew that space, but apparently a very new officer didn't know. Sarah explained that a rookie parking officer had decided Marcus's black Lexus was illegally parked and had called for a tow. The car was already on the flatbed of the tow truck being prepared to be taken away. Marcus was momentarily stunned. He asked how this was possible. The space had clear signage. His car had an official court sticker on the windshield identifying it as a judicial vehicle, and he was literally parked in front of the building where he worked, where his name was in the directory in the lobby, where he presided over public court 5 days a week. Sarah said she had tried to explain this to the officer, but he had insisted the space didn't have proper signage and that cars couldn't park in a no-parking zone without adequate authorization. When Sarah mentioned it was the judge's space, the officer said he saw no evidence of that, and that if Marcus had a problem with the tow, he could contest it at tow hearing like anyone else. Marcus walked down the stairs quickly, his judicial robe still on, and exited through the main courthouse entrance. There was his black Lexus on the tow truck flatbed, chains already fastened around the front wheels. A young parking officer stood there with a clipboard, filling out paperwork. The officer was white, appeared to be about 23 at most, and wore a department parking officer uniform that looked too new on his thin frame. His badge said, Officer J. Morrison. The tow truck driver, a middle-aged Hispanic man Marcus recognized from occasionally seeing in the courthouse area, stood next to his truck looking extremely uncomfortable with the situation. Marcus approached calmly and said good morning to Morrison. He explained there was a misunderstanding, that this was his car, that the space was designated for him, and that if Morrison looked at the permanent metal sign affixed to the post directly beside the space, he would see it said, Reserved, Judge Ellison. Morrison looked at the sign, then back at Marcus in his judicial robes, and then said something that would make this story spread through the legal community for years to come. He said anyone could wear judicial robes, that there was no photo on the sign so he had no way to verify identity, and that the car was in violation regardless of who claimed to own it because the signage was inadequate. Marcus asked calmly how exactly the signage was inadequate. There was a permanent metal sign with his name and title. Morrison said proper signs had to be green with white lettering according to municipal regulations, and that sign was blue with white lettering, so technically it wasn't in compliance with code. Marcus explained that sign had been there for 12 years, had been installed by the city's Public Works Department, and that its non-compliance with a recent regulatory change, if indeed it was non-compliant, didn't invalidate the underlying authorization. Morrison said he was just enforcing regulations as written, and that if Marcus wanted to contest the tow, he could go through the appropriate hearing process. Marcus felt a mixture of disbelief and frustration growing. He told Morrison he was literally Judge Marcus Ellison, that he presided over court in that building, and that if Morrison would simply go into the courthouse and ask any employee, they would confirm his identity and ownership of the vehicle. Morrison said he couldn't leave his post to go verify stories that many people claimed to be someone important when caught in violations, and that the tow was going to proceed. Marcus pointed out there were a dozen attorneys, court employees, and even judges coming out of the building at that very moment who could verify who he was. Morrison looked around, but made no move to ask anyone. The tow truck driver, whose name was Carlos and who had worked tows in the courthouse district for 15 years, finally spoke. He told Morrison this was definitely Judge Ellison's car, that he parked there every day, that everyone in the area knew that car and that space. Morrison said Carlos wasn't an authority on parking allocation and that he should complete the tow as instructed. Carlos looked at Marcus with an apologetic expression and said he was sorry, Your Honor, but that he had a contract with the city and technically had to follow parking officer orders even when the orders were obviously ridiculous. Marcus nodded understandingly. He knew Carlos was in a difficult position. Multiple people had now stopped to watch the scene. Among them was attorney Patricia Mills, who had practiced in Marcus's court for 10 years and had a case scheduled for hearing with him that afternoon. She approached and said hello to Marcus, then asked what was happening. Marcus explained the parking officer was towing his car from his designated space despite clear signage. Patricia turned to Morrison and said she could verify this was indeed Judge Ellison, that she had known him professionally for a decade, and that there was an obvious misunderstanding that could be resolved immediately if Morrison would simply cancel the tow. Morrison said he couldn't accept unofficial verification from random third parties. Another attorney, Michael Torres, joined the group. Michael was president of the local bar association and had known Marcus for 20 years, since before Marcus became a judge. He told Morrison he was witnessing a significant error being made, that this was definitely Judge Marcus Ellison, and that towing a judge's car from his designated space in front of the courthouse where he worked was probably one of the most misguided decisions Morrison would make in his career. Morrison said he was just doing his job, enforcing regulations, and that if all these people were so certain, then Marcus would have no problem getting his car back after the appropriate hearing process. Marcus pulled out his wallet and offered his driver's license to Morrison, showing the name Marcus Ellison matching the name on the reserved sign. Morrison looked at it and said a driver's license didn't prove. He was a judge, just that he had that name. Marcus then pulled out his official judicial business card that had the state court seal and identified him as Honorable Marcus Ellison, District Court Judge. Morrison said anyone could make business cards. The circular logic was becoming farcical. Marcus asked what exactly would be necessary to verify his identity to Morrison's satisfaction. Morrison said Marcus could come to the parking office with appropriate documentation after the tow was complete. Sarah Chen, Marcus's judicial assistant, had gone back into the building and now returned with Chief Court Administrator Robert Garcia. Garcia was responsible for all non-judicial court operations, including security, facilities, and parking. He approached Morrison and identified himself as Chief Administrator. Garcia said he had personally supervised installation of that reserved sign 12 years ago, that it was an official designated space for Judge Ellison, and that he was ordering Morrison to cancel the tow immediately. Morrison said Garcia had no authority over parking officers, that they reported to the Transportation Department, not to court administration. Garcia said the court had jurisdiction over court property, and the space was on court property. Morrison was now surrounded by a growing crowd of attorneys, court employees, and curious passers-by, all witnessing a rookie parking officer insisting on towing a judge's car from the judge's designated space in front of the courthouse. Someone had started recording on a cell phone. Marcus noticed this but didn't intervene. Documentation would probably be useful given how absurd the situation was becoming. Morrison seemed increasingly defensive as more people joined in, confirming Marcus's identity. But he had committed to a course of action and apparently preferred to double down rather than admit error. He told Carlos to complete the tow. Carlos hesitated, clearly not wanting to be part of this, but eventually began operating the truck's controls to fully elevate Marcus's Lexus. Marcus made a decision. He told Morrison he wasn't going to physically interfere with the tow, but that he was putting Morrison on official notice that he was removing a vehicle from a legally authorized space belonging to a presiding judge, that multiple witnesses, including the chief court administrator, had verified this fact, and that Morrison would be personally liable for any costs, damages, and legal consequences resulting from this action. Morrison said Marcus could file any complaints he wanted through appropriate channels. Marcus said he certainly would, and given he was a judge familiar with the legal system, he knew exactly which channels to use. The implication was clear, but Morrison seemed not to comprehend the gravity of what he was doing. The Lexus was fully loaded onto the truck. Carlos handed Marcus a tow receipt listing the location where the car would be stored and the fees that would be due for recovery. The fees included tow, daily storage, and administrative fee, totaling $345 for the first day, with an additional $100 for each subsequent day. Marcus accepted the receipt, thanked Carlos for his professional courtesy given the impossible circumstances, and watched his car being driven away. Patricia Mills offered to give Marcus a ride to the tow yard to recover his vehicle immediately. Marcus thanked her, but said no, that he was going to document this appropriately first. Marcus returned to his chambers and immediately called the presiding judge of the court, Chief Judge Sandra Williams, who supervised all district judges and maintained relations with city administration. Sandra listened to the story with growing disbelief. She said she was going to contact the transportation department director immediately, that this was embarrassing for the city, and that Marcus should definitely recover his vehicle without paying any fees. Marcus said actually he preferred to pay the fees and keep all receipts. Sandra asked why. Marcus explained that if he used his judicial position to avoid fees, Morrison could argue Marcus had received special treatment. But if Marcus followed exactly the same process, any citizen would have to follow, including paying fees for an unjustified tow. Then he would have a stronger basis for any subsequent legal action. Sandra understood immediately. She had been a judge for 20 years and knew how to build a legal record. She said Marcus was absolutely right, that he should document everything meticulously, and that she would ensure city administration knew this was being taken very seriously. Marcus then called his personal attorney, Thomas Chen, who had practiced municipal law for 30 years. Thomas listened to the story and began laughing, not because it was funny, but because it was so absurdly ill-judged on Morrison's part that the legal consequences would be significant. Thomas said this touched multiple areas of potential liability, including illegal taking of property, abuse of governmental authority, and possibly malicious prosecution if Morrison had reason to know he was wrong but proceeded anyway. Marcus spent the next hour documenting everything while it was fresh. He wrote a detailed account of the incident, including time, location, all people present, what each person said. He obtained written statements from Sarah, Garcia, Patricia, Michael, and 3 other attorneys who had witnessed the interaction. He had Sarah copy surveillance footage from the courthouse security cameras that looked out at the parking area, capturing a different angle than cell phones had recorded. He photographed the reserved sign, his car on the tow truck, and the receipt Carlos had given him. Every piece of evidence was meticulously cataloged and preserved. Marcus had spent a decade on the bench, teaching attorneys about the importance of proper documentation. Now, he was applying those same lessons to his own case. Marcus canceled his afternoon hearings, asking Sarah to notify all attorneys that cases would be rescheduled due to unforeseen circumstances. The local legal community was small enough that news of the tow was already spreading rapidly. Multiple attorneys called offering assistance or simply expressing solidarity and disbelief. Marcus thanked everyone, but said he had the situation under control. He then did something deliberate. Instead of using his title or connections to recover his car quickly, he drove with Patricia to the tow yard and went through the exact process any citizen would have to follow. He waited in line for 25 minutes. He filled out forms. He paid $345 in cash and obtained a detailed receipt. The clerk at the tow yard counter recognized Marcus and looked mortified. He began apologizing, saying he had no idea it was a judge's car, that the parking officer hadn't mentioned that. Marcus said calmly it wasn't the clerk's fault, that he was just doing his job processing a tow that had been ordered. The clerk said he could process an immediate refund if Marcus presented appropriate documentation. Marcus thanked him, but said he preferred to keep the receipt for full payment. When his Lexus was brought out, Marcus inspected it carefully, documented with photos, and verified there was no damage. Then he drove back to the courthouse and parked in his designated space, the same space from which he'd been towed 3 hours earlier. Back in his chambers, Marcus began researching legal precedents. He discovered there was surprisingly little case law about parking officers towing vehicles from officially designated spaces despite clear signage and multiple identity verifications. But there was extensive case law about taking property without due process, about abuse of governmental authority, and about negligence by municipal employees. Thomas Chen called back with initial analysis. He said Marcus potentially had multiple causes of action. He could sue the city for unconstitutional taking of property. He could sue Morrison personally under qualified immunity theory, though that would be complicated. He could seek not just reimbursement of fees, but also damages for inconvenience, loss of time, and emotional distress. But Thomas suggested something different. He said given Marcus's position as a judge, this had potential to be a case that created precedent about limits of parking officer authority and importance of following proper identification and verification. Instead of simply seeking monetary damages, Marcus could use this to force policy changes that would benefit all citizens who might face similarly unjustified tows. Thomas recommended dual action, formal complaint through city administrative channels seeking reimbursement and policy changes, and civil lawsuit seeking nominal damages, but establishing legal principles about appropriate procedures parking officers should follow before towing vehicles from designated spaces. Meanwhile, Morrison had returned to the parking office and reported the tow as routine. He apparently hadn't mentioned to his supervisor that he had towed a judge's car from the judge's designated space in front of the courthouse, despite multiple people verifying the judge's identity. His supervisor, Sarah Martinez, found out about the incident when the transportation department director called demanding to know why one of his officers had embarrassed the city by towing a judge's vehicle. Sarah immediately pulled Morrison into her office and asked what exactly had happened. Morrison maintained he had followed appropriate procedure, that the signage wasn't in compliance with code, and that the person claiming to be a judge hadn't provided adequate proof. Sarah asked if Morrison realized multiple people, including the chief court administrator, had verified the judge's identity. Morrison said he couldn't rely on unofficial verification. Sarah asked why Morrison hadn't simply walked into the courthouse, literally 50 feet away, and asked any official court employee to verify. Morrison had no good answer for that. Sarah then asked if Morrison had checked the vehicle registration database to see if the car was registered to Marcus Ellison, matching the name on the reserved sign. Morrison admitted he hadn't. Sarah asked why not. Morrison said he had assumed if someone was parked illegally, they were probably using a borrowed or stolen car. The logic was so circular and poorly founded that Sarah realized she had a serious problem on her hands. The story leaked to local media within 12 hours. One of the attorneys who had recorded the incident on cell phone posted a clip on social media with caption describing how a rookie parking officer had towed a judge's car from the judge's designated space directly in front of the courthouse. The video went viral locally, then regionally, then nationally. People were fascinated by the pure absurdity of the situation. Comments ranged from disbelieving laughter to serious debates about over-enforcement and lack of judgment. Local news stations covered the story, sending reporters to interview witnesses. Patricia Mills gave an interview describing how she and multiple other attorneys had verified Marcus's identity, but Morrison had refused to accept that verification. Garcia gave an interview explaining he had personally authorized and installed the reserved sign and that there was absolutely no doubt that was the judge's official space. The transportation department issued a statement apologizing for the incident, saying they were investigating and that Judge Ellison should not have been subjected to such inconvenience. The statement carefully avoided directly blaming Morrison, but made clear an error had been made. Marcus declined multiple interview requests initially, saying it wasn't appropriate for a presiding judge to make public statements about potential litigation. But he issued a brief statement through the court's public relations office, saying he had paid all tow fees as required, that he had fully documented the incident, and that he was considering appropriate options to ensure such an error didn't occur again to him or any other citizen. Marcus filed a formal administrative complaint with the city 3 days after the incident. The 10-page complaint detailed the complete timeline, included witness statements, referenced video footage, and meticulously documented each moment where Morrison had an opportunity to verify information, but had chosen not to. The complaint sought full reimbursement of the $345 in tow fees, compensation for 3 hours of lost work time that Marcus calculated at $450 based on prorated judicial salary, and implementation of specific policy changes. The policy changes included mandatory training for all parking officers on recognizing officially designated spaces, requirement that officers must make reasonable verification of identity when presented before towing, and creation of a hotline that court officers could call if they believed an official vehicle was being improperly towed. The Transportation Department Director, William Jackson, met personally with Marcus 1 week after the incident. Jackson was a career administrator who had managed municipal transportation for 15 years and was clearly mortified by what had happened. He apologized profusely, said Morrison was a very new officer who had completed training only 6 weeks earlier, and that he obviously needed additional supervision and instruction. Jackson offered immediate refund of tow fees plus $1,000 in additional compensation. Marcus said he would accept refund of fees but not additional compensation unless it was accompanied by the policy changes he had outlined. Jackson said he was authorized to implement those changes and that they would be effective immediately. But Marcus had decided administrative complaint wasn't enough. He instructed Thomas Chen to file a civil lawsuit against the city and Morrison personally. The lawsuit, filed in state court, alleged unconstitutional taking of property in violation of the Fourth and Fifth Amendments as applied to state governments through the 14th Amendment, abuse of process, intentional infliction of emotional distress, and negligence. The lawsuit sought $500,000 in damages. The amount wasn't about Marcus's financial need. It was about establishing there were significant consequences when government employees took property without following appropriate procedures. The lawsuit also sought declaratory judgment establishing specific standards parking officers should follow before towing vehicles from designated spaces. Marcus's lawsuit made national headlines. Legal organizations issued statements both supporting and questioning whether it was appropriate for a judge to sue the city where he presided. Marcus had anticipated that concern. He immediately filed a motion to transfer the case to a different judicial district, requesting it be presided over by a judge from a different county to avoid any appearance of conflict of interest. The motion was granted, and the case was transferred to Judge Margaret Foster in an adjacent county. Foster was a respected judge with 20 years of experience and a reputation for impartial fairness. Marcus also voluntarily recused himself from presiding over any future cases involving the Transportation Department or parking officers to ensure there wasn't even a perception of retaliation. The city tried to settle immediately. Their lawyers knew they had a losing case with terrible facts. Judge towed from his own designated space, multiple witnesses, including Chief Court Administrator verifying identity, officer refusing to make basic verification, all captured on video from multiple angles, and a judge who had meticulously followed every appropriate procedure, even paying fees he didn't owe, building perfect record for litigation. The initial offer was $50,000 plus full implementation of all policy changes Marcus had requested. Thomas Chen rejected the offer, saying it didn't reflect the gravity of what had happened or establish adequate precedent about employee accountability. Negotiations continued for months. The city increased the offer to $125,000. Thomas counter-offered $350,000. Depositions were scheduled. Morrison would have to answer questions under oath about his training, his decisions that day, and why he had refused multiple forms of verification. The city didn't want those depositions becoming public, especially given media interest in the case. Experts were hired by both sides. A public administration expert was prepared to testify no reasonably trained parking officer would tow a vehicle from a clearly marked space after multiple people verified the owner's identity. A municipal law expert was prepared to explain how Morrison's actions violated standard procedures and potentially constitutional rights. Morrison also faced disciplinary consequences through administrative channels. Internal investigation concluded he had demonstrated extremely poor judgment, had failed to follow appropriate verification procedures, and had caused significant embarrassment to the department and city. He was suspended without pay for 2 weeks and placed on 6-month probation, during which he would be closely supervised. He was also required to complete 40 additional hours of training on appropriate procedures, recognizing officially designated spaces and importance of reasonable verification before taking enforcement actions. His supervisor, Sarah Martinez, received a reprimand for not having provided adequate supervision during Morrison's training period. The final settlement was reached 10 months after the incident. The city agreed to pay $275,000 to Marcus. Morrison was personally liable for $25,000 to be paid through wage garnishments over 5 years. The settlement also included comprehensive and binding policy reforms. Every parking officer had to complete 20 hours of training on recognizing officially designated spaces, including how to identify court, government, and law enforcement signage. Verification protocol was established requiring officers must make at least 2 forms of reasonable verification before towing from a designated space, including checking vehicle registration, asking occupants of nearby building or calling verification hotline. And a dedicated hotline was created that any municipal or judicial employee could call to report a potentially erroneous tow, with requirement that tow dispatch would pause until verification was complete. Marcus donated all of his portion of the settlement, minus the original $345 in tow fees he had paid, to a legal aid organization that helped low-income citizens contest unjustified tows. He wrote an op-ed for the state legal newspaper explaining why he had pursued the case. It wasn't about money or personal revenge. It was about establishing that government employees, even those with relatively minor authority like parking officers, had to follow appropriate procedures before taking citizens' property. That verification wasn't a bureaucratic obstacle, but essential protection against arbitrary exercise of power, and that when employees failed to follow those procedures, there had to be meaningful consequences, or the protections had no real meaning. The case, Ellison v. City, became widely cited in municipal government training materials. Transportation departments across the country reviewed their tow protocols and parking officer training. Many implemented changes similar to those Marcus had forced through his settlement. Parking officer training programs began, including modules on recognizing officially designated spaces and importance of verification before taking enforcement action. The case also became a favorite example in law schools, teaching about constitutional taking of property, due process, and governmental employee liability. Professors used it because the facts were so clear and absurd that it made legal principles easy to understand. Morrison completed his probationary period and remained a parking officer, but his reputation never recovered. He was known as the officer who had towed a judge's car, and that story followed him. Colleagues occasionally made jokes. Citizens who recognized him from media coverage sometimes made sarcastic comments. He requested transfer to a different division of the transportation department, but the video of the incident was so widely circulated, he could never completely escape it. Some acquaintances expressed sympathy, saying a single error in judgment when he was a rookie officer shouldn't define his entire career. But others pointed out it wasn't just an error in judgment, it was refusing to accept multiple forms of verification and insisting on a clearly wrong course of action, even when confronted with overwhelming evidence. Marcus's black Lexus continued parking in his designated space every business day. The reserved sign, still blue with white lettering instead of green with white lettering as technical code now required, remained exactly where it was. The city had offered to replace it with new code-compliant sign, but Marcus declined. He said that sign had served its purpose for 12 years before the incident and would serve for 12 more. Besides, it now had additional significance as a reminder that technical compliance with minute regulations was less important than sensible and reasonable application of governmental authority. Years after the incident, when attorneys occasionally referenced it in conversations at the courthouse, Marcus typically changed the subject. He didn't like thinking of that day as a defining moment of his judicial career. He preferred to be remembered for his thoughtful rulings, for his fairness on the bench, for his commitment to due process. But the tow case had served an important purpose. It had established clear legal principles about limits of parking officer authority. It had forced policy changes that benefited countless citizens who otherwise might have been subjected to similarly unjustified tows. And it had demonstrated that even those in positions of authority had a responsibility to hold government employees accountable when appropriate procedures weren't followed. The $300,000 total settlement had sent a clear message. Towing a vehicle without following appropriate verification procedures, especially when multiple people provided verification and clear signage designated the space, had significant financial consequences. Morrison was paying monthly from his salary for 5 years. The city had paid a substantial amount that came out of the transportation budget and required city council approval. And policy reforms had cost additional department time and resources to implement. In the end, what should have been a 15-second stop by Morrison to look at the reserved sign and verify vehicle registration ended up costing the city hundreds of thousands of dollars and creating legal precedent that would be cited for years. For Marcus, the incident had been a humiliating reminder that even judges weren't immune to arbitrary exercise of governmental authority, that the system depended on employees at all levels exercising reasonable judgment and following appropriate procedures, and that when those procedures were ignored, there had to be accountability mechanisms or the protections were meaningless. He had used his position, knowledge, and resources not to obtain special treatment, but to follow the exact same process any citizen would have to follow, building a case that would establish protections for everyone. The towed Lexus from that April morning had led to changes ensuring future citizens, without judicial titles or powerful connections, would have at least some additional protections against unjustified tows. The video of the incident remained online, replayed thousands of times, embedded in training programs, shown in law school classrooms. It captured a moment of pure bureaucratic absurdity, a rookie parking officer so focused on technical enforcement of regulation that he lost all sense of context and reason. But it also captured something more important. It captured a judge calmly, explaining the situation, patiently offering multiple forms of verification, maintaining dignity even as his car was being loaded onto a tow truck. And eventually, it captured that same judge using the legal system not for revenge but for reform, transforming personal indignity into policy change that would benefit others. It was a lesson about due process, about governmental accountability, and about why those with power and knowledge had a responsibility to use both not for personal privilege but for public good.